Again, I'm David Keating. I'm president of the Center for Competitive Politics. We're recording this and it'll be available online. It's also being live streamed today. I wanted to again thank the Cato Institute and the staff of the Center for Competitive Politics, particularly Joe Trotter, our media manager in the back, and Matt Neese, who I don't see right now, but both have been very helpful getting this together. Our final panel is going to review Beyond Citizens United, the future of campaign finance jurisprudence. And for those of you who know our chairman, Brad Smith, well, you'll see he's not here, even though he was supposed to be. There's an illness in his family, and last night he just couldn't make it here today. So standing in for him is Alan Dickerson, our legal director. The interviewer today is Matea Gold, the Washington Post. As you know, probably anyone that's in Washington, D.C. has probably read a number of her stories. She covers money and politics. And before that, a lot of us noticed her work at the Los Angeles Times and Chicago Tribune. So I'm sure she's going to do a great job interviewing our panel. We've got Bobby Burchfield, who's a partner at McDermott, Will and Emery. And he's done a great job when I've heard him argue before the Supreme Court. So it's a pleasure to have him here. He's considered one of the top campaign finance attorneys in the country, and has also received recognition as a lawyer that gives clients among the client service all-star team. And his most recent argument, I think, on campaign finance was on behalf of then Minority Leader Mitch McConnell in the contribution limit case, McCutcheon versus FEC, whereas an amicus, he was given oral argument time. Very unusual thing. We also have Rick Pildes, Sudler Family Professor of Constitutional Law at New York University School of Law. He's one of the nation's leading scholars on public law and a specialist in legal issues affecting democracy. He's the co-author of the acclaimed casebook, The Law of Democracy, Legal Structure of the Political Process, and also a teacher of Alan Dickerson, who now is the legal director of the Center for Competitive
Everything
Politics.
I get wrong is his fault.
Everything he gets right is my credit.
Alan leads our litigation efforts, and we have 10 cases going on right now. He's in charge of all of them, and he's done a great job. I'm sure you're going to be seeing some of Alan's cases are going to move the law in the future, thanks to his great work. Alan has written a number of articles in places including the Harvard Business Law Review, the Naval Law Review, but also can write for the popular press, including Campaigns and Elections and USA Today. He has his degree from Yale and obviously New York University School of Law. So Matea, thank you very much for serving as our interviewer, and let's get going.
Great. It's such a pleasure to be here. So I want to pick up the thread of the last panel and sort of cast us forward a little bit. There was a lot of discussion in the last hour about what Citizens United did and did not do. So Alan, maybe you could set the table for us a little bit. What were some of the legal issues raised in Citizens United that we're still seeing playing out in courts and in legislative bodies across the country?
Well, I like that question, since I actually used to be a corporate lawyer and came to campaign finance only after the Citizens United opinion. So my perspective is perhaps a little different from that of the ACLU lawyers who've been in this fight for decades. In broad strokes, let's recall sort of the doctrine that goes into Citizens United. There's this idea that the government may restrict speech only for certain purposes, and those purposes are narrow. And the sort of central one, and really the only one that's been recognized in this area, is the prevention of corruption. And what the Citizens United Court said was, if you're doing something that's independent speech and it's not coordinated with a candidate, we're going to say that as a matter of law that is not corrupting. But you don't have to worry too much, because it's not that that's the only way that corruption can happen. We have different ways other than flat bans of preventing the ills that everyone is afraid of. And one of those is the fact that disclosure has become more effective in the internet age. It's easier to get this information. This information is more widely available. It can be cross-referenced and checked in ways that didn't exist in 1976 or in some of the earlier cases. I think we've probably spent enough time with Citizens United itself, and I identify, and in many ways you're asking the litigation strategy of the Center for Competitive Politics, But I identify essentially three questions. The first is, when we talk about corruption, what is it that we mean? And this comes out of the Buckley versus Vallejo opinion from the 70s, per curiam opinion, lions of the left, people like Thurgood Marshall were in the majority on this case. And that's sort of been an outstanding question. I mean, when you mean corruption, do you mean anything that might affect an election? Do you mean the gratitude that a politician feels for things that materially help either his chance of election or the chance of advancing some sort of political agenda? What is it that you mean? And that case, in part due to Mr. Burchfield's efforts, the McCutcheon decision in the last term sort of explained that no, what we mean is quid pro quo corruption and the appearance of such corruption, the actual giving of money or favors for official action, that narrow understanding of corruption. So that's the first thing, because that's, I think, a highly contested question. What's the state interest in regulating this area at all? And the second is, the court uses phrases like completely independent when it talks about independent expenditures, about the sort of activity that Citizens United was doing. And there's been a tendency, and I do not have the rhetorical flair of some of our earlier panelists, but there's a tendency that I think is less than fully considered to latch on to those sort of phrases of complete independence, to create this sort of metaphysical certainty of independence. And I think that's another thing that's very outstanding. When we say that activities done independently of candidates, to what extent is that a policeable line? And to what extent is that really sort of an intellectually coherent way of thinking about the outer limits of our regulation of corruption as narrowed by the court? And the third is this question, and I think this is probably the largest area of dispute and litigation at this point. When you talk about disclosure, what do you mean? And we got into this, I think, quite a bit on the last panel in ways that I'd prefer not to add to, although I did provide my business card because I do a lot of these cases. But there's two questions. One is, what triggers disclosure? The grand bargain of Buckley versus Vallejo was something like this. Everyone knows the government can't go poking around in your membership lists and can't ask for your donors and can't do all this stuff. We have this concept of a civil society that undergirds the republic, and it's unthinkable that we would sort of act in derogation of that. But we're just going to have to because of corruption, and so we're going to draw a very narrow exception out of this general understanding of the First Amendment, and that narrow exception is for political activity. And by political activity, we mean when you spend money, when you either give money directly to a candidate, and recall in 1976 the candidate could pocket it, and also that you are saying vote for or vote against this person. That's the line. Well, now that's not clear. I mean, we've talked about 501c4s earlier. We've talked about electioneering communications. I mean, the first sentence of one of our briefs in one of our cases is, this is a case about an electioneering communication that does not electioneer. It really is a sort of, again, metaphysical attempt to co-opt the English language to get to a certain result. And then finally, when you talk about disclosure, what do you mean? Do you mean all donors? Do you mean the organization that's putting its name on something? Are you talking about an actual law that exists in Massachusetts where the CEO of a company must go on the air and say that he, approved this message, even if that's not how your organization's structured in the Commonwealth? So those two related questions of disclosure: what triggers it, and what is it? I think those are sort of the issues that we're still seeing working their way through the courts.
Terrific. I think that tees us up perfectly for this conversation. And Bobby, I'd like to turn to you on the last point that Alan raised on disclosure. So as we've talked about, the concept of disclosure was one of a principle embraced in the Citizens United decision. There actually has also been a history of a lot of conservative support for disclosure, but it's become a really partisan, polarizing issue now. And I'm wondering, do you see from your vantage point any room for agreement between liberals and conservatives on this issue, and any possibility of a compromise in this area?
Well, let me first define what I see as the issue, and then I'll address the issue of compromise. Disclosure has been, as Alan noted, a precept, a fundamental precept in the area of the campaign finance campaign finance since Buckley. But it's always been in tension with the settled case law about disclosure of supporters and potential retribution against those supporters. The growing concern that many conservatives feel about disclosure is it is now being used really as unapologetically as a tool to deter participation in the political process. When Chuck Schumer introduced what he calls the Disclose Act, he made no bones about the fact that if more disclosure were required, there would be fewer dollars spent by the entities that were required to disclose. There's a great history of anonymous speech in this country that goes back to the Federalist Papers. That history continues every day in the newspapers when you see the Washington Post, the New York Times base major stories on anonymous sources. There really should, in my view, there's no question but that anonymity of speech does promote more open dialogue. So that's the tension. At what point does disclosure cease being a public good that informs the public about something they have a right to know about, and transcend into a club to suppress dialogue and to suppress speech? Justice Thomas was wrote a lone dissent in Citizens United from the disclosure holding, and it's a powerful dissent. He attracted no other justice to it, but it outlines some of the history of retribution against contributors to the Proposition 8 campaign in California, where people were threatened with physical violence. They lost their jobs. They were confronted on the street. So there's a real issue here. Now, the second part of your question is there room for compromise? There's always room for compromise among reasonable people. But I think the agendas that are being pursued here, the agenda to allow maximum speech and maximum participation in the political process, does not easily meld with the other agenda, which is to limit participation in the political process. Certain disclosure, point-to-point disclosure of people giving money directly to candidates, I think there's almost universal agreement that is appropriate for disclosure. Political speech that is independent of candidates, I think there's a much more wide disparity of views on that issue.
And just to follow up quickly on that point, do you feel that we talked about, we saw in the last panel discussion about how there's this incredibly complex patchwork of laws and regulations that regulate disclosure that make clearly people who want to participate in the process can make your head spin. Do you feel that the disclosure regimen is robust enough to address what the courts have said is essential disclosure in the system? Do there need to be any changes either direction to adjust how people are required to report their participation?
Well, there are two aspects of that. The first is, what is the administrative burden that is imposed on the person who is disclosing, and the second is, what is the burden of the public to obtain the information. And I think now in the internet age, the information is, once it's disclosed, it is fairly easily obtainable by anyone interested in it. The reporting burden and the burden to determine what needs to be disclosed and when, I think that burden has increased significantly over the last several years.
So Rick, I'd like to turn now to the entities that do disclose, parties. What impact did Citizens United have on parties, and what possibilities are there now for parties to regain some of the kind of heft they had pre-Citizens United? What do you see happening out there?
Well, I'm mostly in agreement with what Joel Gora and Peter Walzen said on an earlier panel, which is we really have to go back and focus on McCain-Feingold in particular when we talk about political parties and not Citizens United in isolation. One of the great myths about Citizens United, which we haven't quite focused on yet, is that Citizens United is responsible for the tremendous growth in outside spending since 2010. There has been that growth, so I disagree with people who said earlier that you can't see that. And you see many academics and journalists writing these stories, like in the Brennan Center report that just came out, comparing outside spending 5 years ago to today. And there is a tremendous growth if you turn the clock on then. Rick Hazen says numbers don't lie. But of course, you have to understand the context in which numbers are generated. So if you just turn on the clock at Citizens United, you see all this outside spending going up. But if you go back to 1998 or 2000 and you look at the rate of growth of outside spending, it goes up much more in response to McCain-Feingold than it does in recent years in response to Citizens United. In other words, there's been a constant growth in outside spending ever since the McCain-Feingold law. And that's the main driver of this explosion in outside spending, not Citizens United. So I share the view that one of the worst things for the American democratic process is the tremendous, what I call political fragmentation that we now live with, which is so much political power being dispersed across lots of different actors. And I'm of the view, because I'm of the view that to make American government function, given separated powers, you are going to have the forces of centrism empowered to make those institutions work across these differences. And for all the ways we disdain political parties and all the things that are awful about them, they remain the most broadly aggregative groups in a democratic system. And so if you disempower political parties by pushing all this money outside, you inevitably, as has resulted, empower the forces at the ideological extremes. So Citizens United, I don't think is a significant factor in the explosion of outside spending and the evisceration of political parties. But I do think we should be thinking about campaign finance regulation and reform in a way that would try to make the political parties, more than the individual candidates and more than the outside groups, the central actors in the system. So that's the only way, perversely or ironically enough, in our polarized world, unless you have strong political parties, you're not going to be able to get the deals made across political differences that can enable a separated power system like ours to actually work. So campaign finance reform, in my view, has done a lot of damage, or the recent reforms in McCain-Feingold, to the ability of the system of governance in the United States at the national level to function effectively.
And we all probably were following the news in the campaign, the rider that was kind of tucked into the Omnibus bill at the end of last year that expanded the amount of money that can go to parties. Alan, is that going to make a big difference? I mean, are parties going to have a surge of new resources through that, or are there other mechanisms in which they're going to be able to regain some extra heft?
Well, I'm probably in the bottom half of people in this room on expertise on the parties, but my sense would be no, it's not going to have a big effect, and that's because the money is so carefully constrained. I mean, it's true that the amounts that you can give are now tripled or whatever it is, but I mean that's not soft money, to push back on an earlier comment. I mean that's money that can be used for things like building buildings. This isn't money that can be effectively deployed for what you would think of as traditional campaign activity. So I mean I think it is helpful in the sense that institutions aren't merely about that activity, and that we should care about the institutional strength of institutions generally, including parties. But no, I don't think it's going to create a substantial comparative advantage for the parties vis-a-vis the rest of society.
And Bobby, what about the McCutcheon decision, which did away with this overall cap on how many party committees and candidates that people could donate to? It seems like it might have not had a massive effect in the amount of money yet, but what's been your perspective?
I think it has had. I think it's had a beneficial effect, and every incremental positive effect helps. I do think that, as was noted on one of the prior panels by Joel Gora and Peter Wallison, that the parties do play and should play a central place in our democracy. They are, as we argued in the McConnell case, as it turned out unsuccessfully, the political parties have an important moderating effect on candidates. The more powerful the parties are and the more resources that they can give to their candidates, the more influence they have on moderating the positions of candidates and perhaps working toward some sort of legislative cohesion. What we've seen in recent years as the parties have been weakened, you've seen outside groups play a larger role. This is played out, most noticeably in some of the Republican primary contests, where incumbent senators and incumbent congressmen have lost in primary battles because a candidate that would appeal to a more conservative range of the electorate was able to attract money and was able to attract outside groups in a way that was able to obtain to win the election. So the parties do not have the influence on the candidates today that they did, I would venture, before McCain-Feingold, before the McConnell decision, and that's I think not a good thing. Strengthening the parties should be high on the agenda. I think there's almost unanimity among the speakers today that strengthening the parties should be on the agenda of any further campaign finance reform. I would make one further point, and that is that the basis upon which the McConnell court upheld the restrictions on political parties were these notions, this expansive notion of corruption, access corruption, aggregate wealth corruption, and so forth, that the court rejected in the Citizens United case and again rejected in the McCutcheon case. And since those notions of corruption were fundamental to the upholding of many of the restrictions in the McConnell case, I think some of the restrictions on political parties, national and state level, are at serious intellectual risk of not being able to withstand a subsequent challenge. And one of the predictions I would have is that maybe not this year, maybe not next year, but sometime, I would think, over the next decade, there will be a serious reconsideration of those restrictions.
And are you talking about actual contribution limits to parties and candidates?
I think the soft money restrictions was the headline of the McCain-Feingold bill. But in order to implement those restrictions, the statute has to impose so many other restrictions on the way the parties operate, the way they transfer money to the state parties, the way national party officials can campaign at the state level and help state parties raise money. There are so many other interlocking restrictions that it has very much, I think, restricted the ability of political parties to be the force in this country that they need to be.
And let's go back to that definition of corruption that a lot of people seized on, especially in the McCutcheon opinion. I think it got even more attention perhaps than in the Citizens United decision. And Rick, how does the way that the court described corruption in that decision, what are the implications for the existing campaign finance regime? Do you agree with Bobby that you think some of the current restrictions are vulnerable to legal challenges now?
I would agree, and I think that the issue that may really dramatically change the system, which is not one that we've directly talked about yet, is if the political parties pursue the effort to essentially apply the Speech Now case to political parties. In other words, if political parties press the argument in the courts that if they set up arms that do nothing but engage in independent spending, are they now entitled to raise unlimited contributions to fund that part of what the party does? If it's just taking out ads, getting its message out. If that gets litigated, and the Republican Party has brought a couple of suits, I think, and then maybe walked away from them for all sorts of internal reasons to raise that issue, the Democratic Party, I noticed that Neil sort of skirted around the edge of this issue. The Democratic Party has been afraid, I think, to take the lead in raising that issue because it's so much more ideologically charged within the Democratic Party. But I think there are many Democratic Party lawyers who are happy to let the Republican Party go out in front on that issue. You would see the most dramatic change in the campaign finance system, and one that would put the political parties much more in the front and center again, and a certain amount of the money now going to outside groups or super PACs would come back into the parties if the parties successfully litigate that issue, which is a slightly different question than relitigating the issue the parties lost on in McConnell.
Right.
And I think there's a lot more sympathy on the Supreme Court now, not just from the most sort of deregulatory kind of justices, most pro-First Amendment in terms of the way this conference has talked about the issue. But I think justices on the court increasingly recognize that the system has become highly distorted. Most of them don't have any great love for all this money going to outside groups. You see that cropping up in opinions. So I think the political parties may get a more receptive audience at the court, not just from the 5 justices in the majority in Citizens United, but from some other justices on the court. I think there's more recognition that regulation can't staunch the flow of money. It can only rechannel it in some directions versus others. And the worst direction to channel it in is away from the candidates and campaigns and away from the political parties and into the hands of Americans for a Good America, or whatever the group is called.
Well, Bobby, let me briefly put you on the spot, and not to ask you to reveal any attorney-client privilege, but I know the RNC was pursuing a case like this. Hypothetically, do you think we will see the RNC take this up again in 2015?
I think that is a complicated issue, both legally. I agree with Rick that there's a strong case to be made there, but it's also a complicated case jurisdictionally, because the restriction at issue there, at least the district court believed that was not an issue that was directly certifiable to the Supreme Court. That went directly to the U.S. Court of Appeals for the D.C. Circuit, sitting in Bank. And that is not a court that is necessarily as sympathetic to these issues as the current Supreme Court is.
So it's a tactical decision.
It had some elements of that, yes.
Right, all right. Alan, let's go to one of the other issues you raised, which was this concept of independence. And I can tell you, as someone who writes about these issues a lot, it's a real challenge to educate not just our readers, but sometimes my editors, that independence doesn't necessarily mean the colloquial definition that the average person has of independence, that there is actually a lot of space in the law and in the statute for creatively independent outside groups to have communications with sort of the hard money side. But what is can you define for us, what is the kind of, what are the lines on independence now, and what are some of the challenges that you see coming towards the walls as they have been erected so far?
Well, the first challenge is answering that question. The fact is that to really determine whether a particular communication or expenditure is independent of a party, you have to ask a bunch of sort of how many angels on the top of a pin type of questions. And this involves reading not only the statute, which you'll recall a lot of this comes out of the case law and not the statute. It involves reading the FEC's regulations, which are a whole book. It involves reading their advisory opinions, which vary significantly in length and quality. It involves reading staff guidance. There isn't sort of a nice section where you can go into the U.S. code and look up independence and get an answer. So I mean, that's the first problem, is that I think it is probably malpractice to answer that question in the general.
Well, that's telling.
And I think so that's the first thing. And the other is that, that leads to this other question, which I know Gabe mentioned earlier, which is, this stuff has become so complicated, and it hasn't just become complicated in the way lots of regulations become complicated. I mean, if you want to put in a sewer system, that's complicated because there's a whole bunch of EPA regulations. Okay, but the ability to put in a sewer system, depending on who you ask, is not a fundamental right of sort of guaranteed by the Bill of Rights in the same way. So the independence issue, I think, is a good test case for this, because you have to choose. You can say, we need a really good, bright line that your person of average intelligence will understand. But if you do that, you're inevitably going to end up with something that's either over-inclusive, if you're from the view that says, independence has to leave some room for civil society that isn't regulated, or it's going to be under-inclusive if you're one of these people who thinks that, the fact that I'm, if I were hypothetically, which I definitely am not, a public personality, and I go out and say something, nice about the president who's up for re-election, that he's going to owe me a favor in some way, and that's corruption. And so I think you're ending up with this problem that you just can't draw these lines in a way that's predictable, that can be applied in a general sense. And so campaign finance law really has become not a body of law so much as a body of exceptions, and a body of sort of applications of generalized principles to specific fact patterns. And the danger in that is that because what we're talking about is politics, everyone sees the fact patterns differently.
Right. Well, so doesn't that undermine kind of the foundation, not just of Citizens United, but of Buckley? If you can't define what independence is and where that line is, I mean, Bobby, how do you answer that? I mean, is that several campaign finance lawyers have said to me in recent years who are practice this law and struggle over it, that they're starting to doubt the whole logic of Citizens United because of this tangled mess that they find themselves in.
Well, I agree with Alan. It's a challenge to define independence. That's been an issue though that goes back for years and years. When I was at the campaign in 1992 as general counsel for President Bush's reelection campaign, we had ongoing investigations from 1988 alleging coordination between the 1988 Bush campaign and outside groups. In fact, it was Citizens United, or a precursor of Citizens United. And at that time, at least, the notion of coordination was much, I would say, even much less defined than it is now. The Federal Election Commission has made an effort to put specific criteria on the notion of coordination, and so you can actually go to the Code of Federal Regulations and see what they're going to be looking at for purposes of coordination. So there is some guidance. I do agree that it is the sort of concept that does have the potential to discourage and chill speech because people don't want to go through the prospect of being investigated by the Federal Election Commission, and anyone at any time can make an allegation that speech is being coordinated.
So, Rick, what is the solution to this? I mean, since we have this legal system now that is premised on sort of these two sides, where there's a less regulated soft money side and can't really coordinate directly according to a very narrow set of rules with the hard money side and the candidates, but that's increasingly, there's questions about what that wall is. I mean, what do you see happening with that void of real clear guidance, and is there a clear solution?
Well, let me start with one possible compromise solution. I don't know if Bobby thinks I'm a reasonable person in offering this compromise. I think we may end up moving in a direction where there's a lot more weight put on disclosure and less on prohibitions of various sorts. And I think that a possible source of compromise on disclosure, which picks up on some of the concerns Bobby raised, not all, is that liberals in favor of broad transparency and disclosure have to recognize that we have set disclosure levels way too low at this point. They were set at $250 for federal campaigns back in 1970, in the 1970s law. They haven't gone up since then. That, as people have said, that was in a pre-internet world. Now, I tell my students who different faculty members have contributed to, just so they know how easy it is to get this information. And we are hearing horror stories. The story about people contributing to the initiative in California against same-sex marriage, the theater director who got fired when it came out that he had disclosed against it. I mean, that, I think, is a political outrage in the United States. Nobody should lose a job over their political participation, even if I don't agree with his views on that issue. And I think disclosure regimes are going to be in constitutional jeopardy if reformers don't recognize the seriousness of this problem and don't make an effort to raise the level of disclosure to a point where, it's actually meaningful information that this person is contributing at this level. So if there's a way to form a political compromise in which, large amounts of money being spent or contributed are disclosed, but the disclosure levels are raised to a much higher point, that might be desirable. There's a political difference that Bobby and I might have, I don't know. There's a real value question about what's proper retaliation, if you will, or I would say proper accountability for political action. So if a corporation like Target, puts a lot of money into a campaign, and people who are its customers don't like the issues it's supporting, and they stop buying at Target, I think that's perfectly appropriate political activity. And if that chills Target from spending as much, I think that's the right dynamic. So I don't think the mere fact that there might be less political speech in that sense. I don't think Target is, the vulnerable guy who's losing his job, or the NAACP activist in the South, back in those cases. But I think there are real issues to work out there. I think the system is going to end up collapsing, and I think that eventually the political parties will come back as major players in the system, because I think the media exemption is out there and it's going to blow this system up to some extent. I think independent spending by political parties is going to rise as an issue, and that may blow the system up to a considerable extent. I think these boundaries between independence and coordination, I'm not even sure what the point of that boundary is exactly. I mean, if we step back and in this day and age, it's very easy to know that the Obama campaign is going to be focused on the, promoting the middle class. And, we're about, improving the middle class. You don't have to have any coordination. You can have pure independence. And all these groups can be completely on the same page as the campaigns. And people who think the system is corrupt, when they see hundreds of thousands of dollars given to those groups, their view about whether it's corrupt or not isn't going to change on these micro issues about is there coordination or not. So, I mean, I'm not sure what the answer to that is. I just think we get so into the technical details of independence versus coordination, we don't step back and ask, well, what is the problem here? Are we actually solving it? And I don't know. I think the system is increasingly feeling the pressure from all these different fronts.
And so, Alan, is the center pursuing cases around the country challenging contribution limits? And if so, are you having success in that area?
Well, we do a number of things. I mean, we do have at least one case on contribution limits. Although our general approach to contribution limits has been similar to the approach of McCutcheon of saying, if you're going to have contribution limits, they have to make sense. If it's okay for an incumbent to take $5,200 for the general election by getting the check the day before the primary, in which incidentally the incumbent doesn't face a challenger, maybe people should be able to give that same amount of money in the general election for people who did face a challenger. I mean, what exactly is the anti-corruption rationale of dividing these things up in these strange ways? Most of our litigation, I think, has been sort of on more of either the disclosure point, although taking a somewhat softer view than Bobby, and I think partially just because it's how to put this, it's a more interesting question. I mean, the law on contribution limits in the sense of direct money to candidates, I think, is not terribly vulnerable. It has, long and universal political acceptance. There are certainly some of us who see problems with it, but we live in a world of scarcity and have to choose our battles. And on that point, I mean, just to add something to what Professor Pildes was saying, we got on a first-name basis after the 10-year reunion. I think part of the problem is that there isn't a theory of disclosure. No one's done the intellectual work, or maybe people have and it just hasn't filtered into the courts, of saying, what exactly is it we're trying to get at? I mean, we at the center use this phrase junk disclosure, just this idea of, does it really help? I mean, thankfully I'm married, but back in the day, if someone wanted to Google me before a date and figure out who you wonder how society gets totally atomized. That's how it gets atomized. Both in the sense that, is it really in the public interest for everyone to make every economic decision based on whether Target supports what they like or not? That information gets amalgamated, it gets put on a website. You can go and do these things if you think that way around the world. I think it takes a lot of effort, and maybe you should be working longer hours at your job, but leave that aside. And there's also this other problem that no one's really thought about, which is the temporal problem. When you talk about disclosure, you're usually saying, we want to know who's influencing the people who are running for office now, the political decisions that are being made now. We want that sort of feedback. There's a lot of sort of, instantaneous reporting or 24-hour reports or whatever else, because we're really interested in that real-time interaction between government power and civil society. But is that really how it works in the age of the internet? Think about the Prop 8 case. Prop 8 was not brought last year. There's been social change on the marriage equality issue over the last decade. People who made those decisions and contributed to that campaign may no longer hold that position. The President of the United States doesn't. And there's this issue about disclosure, not only of it being such a small amount, but the fact that it exists forever. It's the fact that everyone is the people who got photographed in the civil rights, era. Everyone's political experience over the course of their lifetime is now public knowledge. And that maybe we should be thinking ahead to, if we want a society where people are going to engage, do we want them to make 30-year bets about their ideological commitments?
You want a right to be forgotten with disclosure?
I'll leave that to the Libertarian Committee. But I think it's something to talk about.
So, Bobby, just to end our discussion, I want to get to a related issue, which is that the IRS is undergoing a rulemaking process right now regarding how to handle this incredibly thorny issue of what is political activity for 501c4 and possibly 5 and 6 organizations. So what are the prospects for that, actually impacting the coming 2016 cycle, and do you think actually they'll even be able to successfully put rules out?
Well, I think the IRS, which was a bit vulnerable going in light of the controversy it had about investigating certain groups, when it issued the notice of proposed rulemaking, really kicked a hornet's nest here, and ended up getting something like 137,000 comments regarding the rule. It's a very complicated rule. It's an area where groups across the political spectrum have a vested interest, and I personally do not think the IRS is going to be able to get a rule in place for the 2016 election that would do nearly as much as the proponents of the rule wanted to do if they're ever able to get a rule in effect. But that's just a guess.
And Rick, I think because we're running out of time, or we can continue for a few more minutes, but I just wanted to end on this question of the C4 organizations, because that seems to be this area in which everyone's sort of wrestling with. The left is starting to embrace more of these vehicles as well to do political engagement. There's clearly some advocacy groups out there that are very obviously advocacy groups that stay in their lane. There's other groups that wear the cloak of an advocacy group but seem to be a political organization. What are your thoughts on the kind of legal and legislative answers for dealing with that issue, or is there anything to be done?
Well, maybe I can give a big picture answer that doesn't directly speak to the 501c4 issue, because I want to at least put this idea out there for people as a way of conceptually thinking about the whole area, even though I know it's politically completely ridiculous as a policy proposal, and even in this room, I'm sure most people would recoil at the idea. But I think that if we keep trying to chase down the money in a privately financed election system like this, and we're going to always have new vehicles that develop, and then issues about these vehicles, and what's the legal boundary about them, and can we get Congress to actually legislate in this area? Can we trust administrators? So in my thinking about this, I move more in the direction of thinking that if the system comes under all these kinds of pressures that makes it very untenable to sustain a larger and larger and larger regulatory apparatus, if we had public financing of campaigns, but in a very different way than it's typically talked about in the United States, which is we have a candidate-centered system in every way we regulate elections, highly individualistic, characteristic of the United States in many ways. If you had a public financing system that channeled the money through the political parties, without suppressing independent spending or anything like that, but if you could get lots of money flowing to the political parties through public financing, a lot of these other issues would diminish in significance. The parties would be central actors. I think, as many people have said, it'd be much better for the democratic system. Obviously, there are lots of issues about how you set up a public financing system and no political support for it. But conceptually, I think that's actually a very productive direction for thinking about these issues and putting these constant fights into some larger framework. What are we trying to do? Are we making our system better or worse?
Alan and Bobby, would public financing get any traction among the folks you work with?
It's voted on every year on April 15th on the tax checkoff, and from a high water mark when it first appeared on the IRS form in 1977, when it was at about 28%, it has fallen every single year, so that in the past year, the most recent statistics I've seen, about 7% of the American public checked the box, even though it doesn't cost them anything. So I think there's just no political support for public financing, and I think it's not politically viable, and I also don't personally think that it would raise the level of public participation or public involvement in electoral politics the way some of its proponents claim.
What about a tax credit or deduction? I believe a Republican congressman from Wisconsin has proposed that. That's gotten a little support, bipartisan support.
Again, I think it's, people are going to contribute to political campaigns or going to do so. I would imagine a tax credit might engender somewhat more participation than the checkoff, but the checkoff is free money. A tax deduction is still going to cost you whatever your tax rate is.
Right, right. All right, well, I think we're going to end the discussion there. Thank you, all three of you, so much for a great discussion.